Hi, this is Dr. Steve Thompson. Again, this is chapter 5. We're going to be talking about in the ethics course. We're going to be talking about the judicial system, focusing mostly on lawyers, but a little bit about judges. So I'll be doing chapter 5 in the PowerPoint, so you're welcome to follow along with me. A lot of people think about a defense attorney as being deviant, a bad person, takes a guilty person and tries to get them off on a technicality or befriends people who are just terrible people. And I've kind of joined a long time ago. I had that same thought process. Like, the police would never arrest somebody and charge them with a crime that they didn't commit. You know, it just can't happen. And over my many years working in the criminal justice system, I've seen where it does happen. I've seen where even I've been encouraged to arrest innocent people. And you're thinking, and I was even thinking, what would be the motivation for that, to just completely arrest an innocent person? And there are a few cops out there who got caught just planting drugs on completely innocent people. But you know, what is the motivation behind that? And it simply comes down to, in most instances, self-serving in some way. So, like, for me, I was encouraged, hey, arrest people for DWI. Get as many as you can, and the supervisors will stay off your back. And so I complied with the request to arrest drunk drivers. I was trained how to do it, and I did it to the standard, and I felt good about the arrest because, you know, the training was hard. It wasn't really that hard. The training was specific, and you had to know what you were doing to arrest somebody for drunk driving. So I did that, and it was a big deal to the person that got arrested, and I took it very seriously. But the way I did it, they're like, how do you get so many drunk drivers? And a lot of people would ask me, and it's not hard to figure out. Just listen to the radio or look at the radio logs. I stopped a lot of people. If it moved after 1 or 2 o'clock in the morning, I stopped it. When I stopped it with probable cause of a traffic violation, anything like not using a turn signal, or a tail light was out, or even their license plate light being out. 2 o'clock in the morning, somebody's driving around. There's a lot of time they've been out drinking and decided to drive after that. So you stop them for, we'll say, no license plate light. Very common traffic violation. People just don't check it. Even the inspection places don't get it. You pull them over, call them out of the car, and they're completely sober. Hey, your light is out on your car. Drive carefully, have a nice night. And that was the end of it. But a lot of times those people would be drunk, or they would exhibit a traffic violation such as, behavior consistent with somebody who was drunk driving, like driving left of center, speeding, just any traffic violation, like I said, drifting in the lane, drifting out of the lane, failure to use a turn signal, running a red light, so forth. So, but some of my fellow troopers were trained to just get the stat, it was called. So you pull somebody over, and if you can get away with it, arrest them. Let's say they've been drinking a little bit, or they admitted to drinking, they give you something, or you just think they are, then you don't have to. They don't want to make a lot of stops. They just want to get their drunk and go home. In fact, Louisiana State Police Troop D here locally had a policy in place. It was informal. It wasn't written down because it was a felony to write it down and do it actually the way they did it. But they were told that if you get a drunk driver, as soon as you're done processing the drunk driver, put him in jail, whatever, you were done for the shift, but you still got your paycheck. You got paid like you worked the entire shift. So can you imagine? You're like, wait a minute, I only have to work a couple of hours, get me a drunk driver, and then I get to go home and sleep. That's really nice. And so that was happening, and that encouraged people to maybe arrest somebody that wasn't drunk driving. And like I said, I was taught that, let's say you get somebody who admitted they had a couple of beers or whatever. They fail the field sobriety test, and if you don't know what you're doing on the field sobriety test, or even if you do, you can say somebody failed it when they actually didn't, or the failure might be attributable to something else like a physical disability. They get arrested. You might even think, hey, this person probably not over the legal limit. And you don't want that number to show up that says they're under the legal limit, because, then you get put in a position, well, do I let them go? Anyway, so one of the tactics that I was taught and that I saw other people use, I didn't use it, but was when you pulled up to the station, you stopped the video camera, and then you walked into the station from the car, and there was a gap in there with no camera coverage, no audio coverage. So anything you said or did was not covered. during that disengagement of the car video till you got inside, this is before body cams. Now I think they use body cams and they're supposed to leave them on. But you talk them into, you basically give them some advice that they don't want to take this test. You tell them, hey, you don't want to take this test because it's going to show you're over the legal limit, and then you're screwed, And then you get in there and you turn the camera on, and you've already told them, you already convinced them, hey, I'm not going to they're not going to blow into the machine. And then you log it as a refusal. Well, when you log it as a refusal, it's like, you look at that and go, well, you refused the test. You could have proved that you were innocent. And that's not the way the law works, but that's the way that's the way I would even look at it. Well, if you were not drunk driving, why didn't you just give a breath test and it would have shown that you're not drunk driving? And you get a lot of refusals through that method. And I never used it, but I saw people who did use it on purpose. And I even know, I know one person who was discouraged from taking the test, but he said, no, I'm going to take the test and show you I'm not drunk. He wasn't drunk. He blew in the machine and it came out triple zeros, which means no detectable alcohol in the system. So, and that was the next way we were trained. Okay, if you think this person might have, we'll say, smoked marijuana a few weeks ago or whatever, or maybe that night, but you got nothing to back it up, but you just say, okay, this person could be on drugs, but you got nothing to back it up. And that's one of the things I did. I was a drug recognition expert. I was able to look at somebody through a different physiological exams to determine if they were impaired upon a drug at that time versus it just being present in their system, like they smoked marijuana a month ago or whatever. Anyway, they could say, okay, well, you might be on drugs or you are on drugs, so let's go ahead and do a urine test. Do the urine test, and then you still get to charge them with the crime of DWI. Let's say they did smoke marijuana a few days prior to that. Well, that's going to pop up, but it doesn't say that they were on it at that time, but that's still evidence that can be used against them in court. So they might actually still get a conviction out of that. Or maybe the drug test, like one instance that I worked on, the drug test and alcohol test came back completely clean. And my question was, well, what do you do when that happens? And the answer was, well, by the time that happens, that's 6 months down the road before they process that test. You've already got your statistic. It's going on there. Your supervisors are happy because they don't care what happens to the prosecution. Sorry, they don't. They should, but they don't. And for me, it's about quality. If you're going to arrest somebody, you should be seeking a conviction. If that charge gets dropped, I would want to know what happened and why. What do we need to do in the future to make sure this doesn't happen and I don't waste 3 hours doing paperwork? So anyway, the stat is still there. So that's the personal motivation. You get enough drunk drivers and they don't call on you. One of my first FTOs as a trooper was to he taught me, basically, he had heard about me and said, I heard you like to work a lot and you're always going, and that's true. It's still the same way. And he said, I'm going to teach you how to slow down. And we would spend an entire shift parked up somewhere. Now, we would park it in his driveway and he'd stay in the house for 3 or 4 hours while I just sat in the car. And I was going insane just sitting there doing nothing. We'd drive to a secluded area like an old cemetery at a dead end road. And he would just sit there for hours and chat on the phone and read, and we would do nothing. He said, I'm teaching you how to slow down. You need to slow down and not stop doing so much work. And that's kind of how he wanted to do it. And if you want to get sufficient numbers that they wanted out of you for drunk driving, you had to stop a lot of people. But if you didn't want to do that, you had to find ways to arrest people that maybe they were drunk, maybe they weren't. So a lot of factors out there. And I say this, I kind of got off track, but the point here is innocent people sometimes do get arrested. Plenty of guilty people do as well, and they're charged and the right outcome is achieved. But the idea to hate a defense attorney, to me, I look at a defense attorney as a person who assures I do my job properly. Because if you think, oh, well, no attorney's ever going to look at this, or, oh, this doesn't matter, sometimes it does matter, because if that person has a good, solid attorney, they're going to protect their rights and they're going to make sure you did everything right. And I respect that. So I've had plenty of attorneys try to challenge my cases. None of them have been successful, but I've seen a lot of, I would say a lot of attorneys. I see one specific attorney, I'll call him out. Adam Johnson, the Johnson Law Firm, challenges a lot of officers' casework and usually, sadly, wins. And I say sadly, he protects the rights of his client, and sometimes he protects people who didn't commit a crime. So with that said, I don't believe lawyers are most of them are deviant people. We have constitutional rights, and it doesn't say when we swear, when a police officer steps in, they step in and they say, I swear to support and defend the Constitution of the United States. And then there's a period at the end of that sentence. It doesn't say unless they're a bad person, or unless they smart off to me, or unless I don't like them, unless they're a person of color, unless they're poor. It applies to everybody, and everybody has a right to counsel. I promise you, if a wealthy person gets arrested, even if they committed the crime, they will have the best defense possible that they can pay for. And I think everybody that is accused, if he can have that or she can have that, then we all should, poor people should have that too. And somebody stepping in, a defense lawyer, saying, hey, let's make sure you did your job properly, nothing wrong with that, in my opinion. All right. It is an adversarial system. We got to understand that. You got two lawyers, the prosecutor and the defense, going at each other. Basically, one trying to prove a case, one trying to make sure that they don't prove a case. That's the system we have in place. So our adversarial sounds argumentative, and it kind of is. So, but that's the system we have in place. Those are our rules. And so, the prosecutor is just as important as the defense attorney. You can't have a defense attorney out there going, I think my client probably is guilty. Let me just go ahead and give you everything you need to win. And that's not how it works. Now, a lot of cases are disposed of in plea bargain, and that's perfectly acceptable for two sides to come to an agreement. And 95% of the cases are solved that way as well. There's the lawyer-client relationship. So if you ever have a retained lawyer, whether it's a publicly appointed, paid for by the government, or you hire a lawyer to represent you, whether it's a civil case or a criminal case, you have it's called privilege information. So what you talk about, you can even say, and it's kind of weird for me, since I retired from the state police, and I get expert consulting cases sometimes, and I will get the information from a clearly guilty client. And I was reading one the other day. It said, what happened? And the suspect, who he said, he wrote it down, or he confessed everything. He said, I was picking up a very large load of drugs and taking them from point A to point B to get money. And I'm not used to that, that they just come forth with everything, because you have to. You can't lie to your attorney, because he can't effectively defend you if he doesn't have accurate information. So, but those statements that I read that were said to the attorney, they cannot be used. I can't even tell you the names, because I would be violating. I'm not a lawyer, but there's something called work product, and work product, basically hiring experts to look at stuff and so forth, is not subjected to release to the prosecution. That's the trick. The prosecutor, if he gets information that says the client, the person is innocent, he has to share that. But the defense attorney does not. If they get something that supports the client is guilty, they don't have to. They're not like a confession. They don't have to give that to the prosecution. They have what's called privilege. So just understand, privileged information, whether it's a civil or criminal case, cannot be obtained by the other side. So, and the attorney, again, can know full well that their client is guilty. And that happens a lot. They say, well, my client's guilty. How do I? So at that point, they can't attack whether he's guilty or not. They have to attack the method that the evidence was obtained, like attack the officer that collected the evidence itself, try to find a way to exclude it. And if they can do that, sometimes that can result in a not guilty verdict or the dropping of criminal charges. For instance, if I was looking at one the other day on a major drug case, the cop stopped the guy and wrote down that this happened, and I looked at the video and none of that happened. It was all, I don't understand what the officer was thinking. Your dash cam recorded everything that you said happened, but it didn't. These traffic violations were non-existent. And so anything that was found after that as a result of a traffic stop without probable cause or reasonable suspicion results in the case getting dropped. And that was because of the work, the work of the defense attorney. I came to the conclusion that it was a bad traffic stop, and so did the judge. So they dropped the case. And that's sad, because, we'll say a drug case, the guy doesn't go to jail for drugs, which, somebody else would just step in and sell his drugs. But what if he was stopped and the officer walked up and there's a dead 9-year-old kid in the back? Now he's not going to be prosecuted, and because all the evidence would be excluded under the right circumstances, and he walks free and then goes and kills another 9-year-old girl because of the deception. I would say lack of probable cause, but it was just lies, the deception of the law enforcement officer. So anyway, moving on. A client in a criminal case, a civil case is different, but a client in a criminal case cannot be forced to be a witness. So they can't get on the stand. They can't make them get on the stand and say, hey, tell me what happened or whatever. They can just sit there and require the state to prove their case beyond a reasonable doubt. They don't have to assist in that. So, but if the client does get on the stand, there's kind of what if the client gets on the stand? If you've watched the movie, The Devil's Advocate with Keanu Reeves, it's a great movie. But, Keanu Reeves knew that the witness would be committing perjury. And, it's kind of an ethical dilemma. But a lawyer is not allowed to suborn perjury, as in to put somebody on the stand knowing that they're going to commit perjury, or even coach them into committing perjury. That's obviously illegal. So, but if the client insists this is what happened, then the lawyer basically says, okay, I'm going to accept what the client says is true. And, we'll say some questionable attorneys might adopt that route. Ethical questions for attorneys. Why do they defend despicable human beings? And I've been involved in a death penalty case before. And I would say that the person that was charged and sentenced to death, he's still pending right now, but, he murdered a law enforcement officer that was trying to help him on video, clear as day. But just prior to that, he killed another person, or at least he was found guilty of killing another person, and apparently was on his way to kill a third person if he would have been able to get away. He shot the trooper when he thought he was going to end up getting arrested, and he probably was. But anyway, we'll say he wasn't the greatest person, and these lawyers that stepped in, because it was a death penalty case, they were very passionate about it. They attacked me pretty hard on the stand when I was being qualified as an expert. But, I didn't like their methodology because they were a little disrespectful, but I understood what they were trying to accomplish, and they were trying to just serve their client and literally save his life. And they truly believe that what they're doing is ethical. But the person that they were trying to save, just, there's no way around it. He's not a good person. And he did terrible things, at least in these situations. Killed one person, killed a cop, and then was on his way to kill somebody else before, after he killed the police officer, the law enforcement officer, he ended up getting stopped by some civilians that were going by. So, but it comes down to the justification is defending the person's human dignity, because regardless of what the person did, we're supposed to consider everybody human beings, even the most despicable of our society. So lawyers, contend that they're defending human dignity and assuring that everybody has constitutional rights. Because if an officer is allowed to get away with it, then eventually none of us are going to have any constitutional rights. The police are going to be able to kick down your door and walk in with impunity. What about it? And an aspect of this is attacking a witness who is telling the truth, but trying to find a way to make them appear less credible. And that's a common tactic, bringing up a prior arrest record, prior accusations, just anything that can say, well, this person might not be being honest, and try to present that to the jury to present that person as being deceptive. Even though, like I said, the officer or the defense attorney may know that person's telling the truth, but in the interest of the best defense, that's his job or her job is to discredit. I mean, especially if it's a good witness who saw everything and telling the truth, there's really no other way to do it other than you can't attack the evidence. You have to attack the person giving the evidence. Let's jump over to the prosecutor. The prosecutor's job is to protect the public and choose and prosecute cases that serve our best interest. And I would say most prosecutors do subscribe to that, but some don't. I won't go. I'm not gonna discuss any specific examples right now, but each decision by a prosecutor it should be based on, true belief that the person is guilty, true belief that they can obtain a guilty verdict, because what's the point in doing it otherwise? So, but the prosecutor has so much discretion. And even if a prosecutor prosecutes a case where they're found not guilty, and you step back and look at it and go, well, this person should have never even been prosecuted. Prosecutors have so much discretion. It's basically absolute immunity where they can't be sued. You might have to spend $20, $30, $100,000 on defending yourself from the army of attorneys that are supplied by the government in the form of the prosecution, and you're still found not guilty, but there's nothing you can do. The jury found you not guilty, the judge found you not guilty, but you can't sue the prosecutor. They just immediately dismiss it because, they're entitled to virtually absolute immunity. We've got something called exculpatory evidence. You have incriminating evidence and exculpatory evidence. Again, if a defense attorney, if I'm a lawyer and I know my client did it, he confessed, or I know of all the evidence supports that he did, and if I find out about something, I don't have to tell the prosecution, where the opposite is true for the prosecution. If the prosecution gets evidence that says the client is not guilty, they have to turn that over to the defense attorney. Like, let's say somebody else comes in and says, no, it wasn't him that did it, it was me. Well, that's another confession for the same crime, and therefore that would have to be disclosed, even if it was highly suspicious or highly suspected that the person confessing actually didn't commit the crime. JonBenet Ramsey, the little girl from late 80s or 90s, anyway, she was murdered and or died some way, and several people confessed to killing her just to get the attention when none of them could prove that they actually killed her. I don't know what kind of person steps in and does this, but it happened several times. Mental illness or something. So, but even, and this is where being an ethical police officer comes into play. If an officer is caught lying, then they're supposed to be put on a Brady list, and the Brady list says, yes, this officer is a police officer and they collected this evidence, but they have to tell the defense attorney. But we got this little caveat over here that says this person has been caught lying, and so their testimony, has to be taken in light of the concept that they've been caught lying. So, and it's a voluntary list, and I've seen a lot of officers lie in court, in reports, and none of them get turned over on the Brady list. So sometimes it does happen, but it's pretty rare. But that's exculpatory evidence. So if you got a cop, as far as I'm concerned, if he's on the Brady list, can't be a cop anymore, because how can you go in court and testify and say, I'm telling the truth this time, just not last time? So if someone's integrity has been proven to be compromised, then, they shouldn't be a cop anymore. But I've seen way too many cops stay police officers like that. They get an administrative job and so forth. I know of one cop right now, I'm not going to say the police officer's name, but has a significant history of criminal activity and lying, but somehow still became a police officer and has yet to be put on the stand. We're just waiting for the opportunity to put this officer on the stand so we can start asking these questions, but the law enforcement agency will not allow it to happen. They're like, any case that this officer is involved in prosecuting, they just don't let it happen. Like if they say we want to go to trial, we're going to have to drop the charges, because they know what's coming. They can't put this officer on the stand, so they just keep them out of criminal investigations. But like I said, roughly a decade of police experience, and this officer has not been put on the stand yet. So we're waiting, I won't tell you the name, but we're still waiting. That's an active situation. Again, exculpatory evidence has to be turned over by law. If the prosecutor becomes aware of information that could tend to support the innocence of the client, not exonerate them. If it exonerates them, they should just drop the case. But if they got anything, we fingerprinted the murder weapon and somebody else's prints came back. Okay, that doesn't mean the person didn't do it. It just means that you didn't detect the fingerprints of the suspect. Maybe he wore gloves. Maybe a cop picked it up and put their fingerprints on it by accident or so forth, or somebody touched it before, but that would have to be disclosed. We talked about plea bargaining a little bit. Anyway, 95% of cases are settled by plea bargaining. A lot of people don't like it. I didn't even like it. I was, not always. I had a guy try to run me over with a truck. That was attempted murder of a police officer. And they just completely dropped it and had him plead to possession of stolen property, because the truck he tried to run me over with was stolen. He was trying to get away from me. I got in his way and he tried to run me over. He even told me he tried to run me over, and he told me I was stupid for for being in the way because he was going to go through me. And I dove out of the way and thought about shooting, but there was too much, there was a passenger, and I didn't want to hit the passenger for sure. And if I missed, I could have hit somebody else. And so I chose not to fire as the vehicle was barreling down on me. I just moved out of the way. But they dropped the attempted murder charge. I wasn't really a fan of that, especially if they didn't even talk to me. So, we make a joke, you get caught for first degree murder and they plead it down to a seatbelt. It's kind of some sarcasm, but that's coming from someone who doesn't have to actually go through the prosecution. And if we were to say, instead of prosecuting, we'll say plea bargaining 95% of the cases, which means no trial prep, no taking up a court date, no months of preparation. If we were to increase that to, we'll say 10%, that would bring the justice system to a halt. Picture, making it 100%, no more plea bargaining. So plea bargaining has its place, and there's just no way to get around that. So, I won't get too much into judges. Just know that they have they have basically absolute immunity as well. They can find you guilty, not guilty, dismiss evidence or whatever, but there's no holding them civilly liable. And at the end of your the PowerPoint there, you got a case study. It's the West Memphis 3, and I put that in there just to take a look at judicial authority and the decisions they've made over the years. If you want to look at that case, it's extremely interesting. Got a lot of famous people involved: Pearl Jam, some rock stars, the Dixie Chicks, which are now called the Chicks now. They got involved to help 3 wrongfully accused and convicted teenagers at the time. They had been accused of killing 3 8-year-old boys when they didn't do it, but it was basically supported. It couldn't have happened without the bias, ignorance, call it downright stupidity of a judge who apparently had political aspirations and wouldn't do anything to, we'll say, make, that was within the interest of justice. So they were convicted, held for a couple of decades, and eventually released. But they're still not actually trying to find the real killer. The real killer is out there. The police know who the real killer is, but they choose not to do anything about it. It was, in my opinion, it was one of the stepfathers of the children that was murdered, who a witness saw him chasing the 3 boys into the woods, screaming at them. And he fit the perfect profile of someone who was capable of something like this. He lied about his alibi, he lied about his whereabouts, but the police his hair was found in one of the ligatures of the boys, which he lived with one of the boys. So, okay, that's a possible, just some accidental contamination, or the hair got in there, but that's pretty damning evidence. And anyway, the police went and talked to the guy after they found the hair in the ligature from DNA reanalysis, after the other other boys had been convicted. And if you get a chance, watch the interrogation involving that. The officer went in and basically said, I don't know, just a country guy from Arkansas. I said, hey, we're looking at that case again. And pretty much like this: you didn't kill him, did you? And he was like, nah. And that was the end of the interrogation. I was like, that's great police work. And, but the problem was the gentleman that had the ligature his hair was in the ligature. The Dixie Chicks got a hold of that and said something about it, and everybody looks at this guy like, oh, you might have done it. And and I was thinking he might have done it as well. And I was thinking he might have done it until he sued the Dixie Chicks for like $50 million for defamation of character. And a defense for defamation of character, I can say, I think you're a bad person, that's expressing my opinion, there's no issue. But if I say you are a bad person, or let's say you are a child murderer, I can't just say that arbitrarily because I might be sued. And if a defense to being sued for defamation of character is truthfulness. So if I were to say you're a child molester or a child murderer, and there's truth, and that could be true, or it's supported that it is the truth, then I can't be sued for defamation. Well, that's how the Dixie Chicks won their lawsuit. My understanding is they found that their statements and so forth supported that it was true that, he murdered 3 children, but the police have done nothing with him. And the reason I'm convinced that he did it is I watched, and when you sue somebody, I told you can't be forced to testify against yourself. But if you sue somebody or you get sued by somebody, civil attorneys can and will question you, and you can't refuse that question. Now, if they say, did you kill these children? You can say, I refuse to answer on the grounds that I might incriminate myself. You can plead the Fifth Amendment. But, he didn't do that. Anyway, this a very skillful interrogator, a woman attorney, she went in and grilled this man. And by the time she was done questioning him, I was convinced that he's the one who killed the 3 children. And I still believe that. But he walks the streets to this day because of judicial and police incompetence. So that's the end of my chapter 5, and I'll see you in chapter 6.